Okay, welcome everyone to our first podcast serving the lending industry. My name is Todd WOHL. We will be providing monthly podcasts on irrelevant subjects for lenders of all types and sizes. Our topics with respect to future podcasts, as things develop in our economy, we will address issues confronting lenders which are of interest. Our speakers have over 100 years of experience representing lenders and assisting them in providing legal expertise, real estate, and asset services. Our discussion today is titled, Getting Ready for the Other Shoe to Drop, Preserving Your Collateral. So welcome. My name is Todd WOHL. I'm a partner at Braun International. Braun International is a global company with offices throughout the United States that serves lenders and the companies that serve lenders, lawyers, and specialists that need valuation, asset sale, and real estate disposition services. I am one of the partners in the company. We have numerous subsidiaries, and we work throughout the U.S., the Mexico, the Caribbean markets, as well as having one of our partners in central London. Most of what we do works with most of what we do provide services to lenders of all different sizes, shapes, needs, and we work with our partners, two of which are going to introduce themselves in a moment. And I'm pleased to have the opportunity to have this first podcast that we hope is very educational, informative, based on what is happening in the business environment today. And of course, this is our first, and this is dated April 23rd, 2020. So with that, I'm going to introduce Barry Smith of Buckhalter. Barry, please, why don't you introduce yourself?
Good afternoon. As Todd said, my name is Barry Smith. I am the chair of the Financial Institutions Practice Group of Buckhalter. Buckhalter has been around since about 1948. We have 9 offices in 4 states, California, Arizona, Washington, and Oregon. And we are creditors' rights attorneys representing primarily financial institutions around the country. Welcome.
Thank you, Barry. Okay, HEMAL, would you like to introduce yourself?
Sure. Good afternoon, everybody. My name is HEMAL Master. I'm the managing partner of Franzel. We're a 2-office law firm in California, headquartered in Los Angeles. I specialize in representation of lenders of all shapes and sizes, banks, private equity, lenders, servicers, all things lender related and workouts and transactional matters. And I think one thing Barry forgot to add was that at one point in his career, he was also a member of Franzel. And so our history goes way back quite a ways at this point.
That's where I learned everything.
Well, thank you both. And again, this is a very free-flowing podcast that we just we felt that would be really informational for everyone listening. We understand that many of our listeners are going to have a varying degree of expertise in the lending industry, no matter what position or many positions that they've held. And so we're going to try to hit on at least this first podcast topics that we think are going to be, very basic and to start out. So with that, Barry, why don't you lead off?
All right. One of the things we want to talk about is basically your security. And as far as your security and personal property, you want to perfect that by filing a UCC-1 financing statement with the Secretary of State. Laws have changed, and they're continuing to change as far as where you file the UCC. But also, one of the problems we're running into is that I can't tell you how often our clients will take motor vehicles as collateral, and they think they are secured by filing a UCC with the Secretary of State, and that doesn't work. You've got to file, if you have motor vehicles, you've got to file with the Department of Motor Vehicles. Also, one of the things that happened about 5 years ago, they changed the law. If you want to terminate your UCC, you can go ahead and do so as a creditor, but also they've now allowed anybody to file a UCC 3 termination statement. So one of the things you want to do is periodically check and make sure your UCC is current and no one, including the debtor, has filed a UCC 3 terminating your perfected security interest. You'd be surprised how often this happens. One of the other interesting issues is many of you, especially using Laser Pro documents, have a blanket security interest, and that covers all of the furniture, fixtures, equipment, accounts receivable, and so on and so forth, and general intangibles. One of the problems with respect to that is that when you go to enforce your rights and remedies, and you want to either go to court or go to the sheriff to enforce them, you need specificity as to what your collateral consists of. You just can't say, I have a blanket, I can go in and get all the business assets of the particular debtor. That does not work. So what you want to be able to do is periodically go in and what we call kick the tires and find out what your collateral is, where your collateral is, do you even have that collateral that you think you have? And these are just some of the things that have gone wrong, but some of the things that you do want to check.
Let me just add a cautionary tale from the most, I think it was about 5 or 6 years ago, along the lines of what Barry's talking about. And unfortunately, it happened to a large, I think JP Morgan Chase, the largest lender in the world at this point. They had extended several loan facilities, credit facilities to General Motors. And in the process of restructuring a couple of the lending facilities, JP Morgan erroneously terminated a UCC1 statement on some collateral that they had on General Motors. Well, General Motors subsequently filed bankruptcy, and JP Morgan Chase was deemed to be an unsecured creditor on a $1.5 billion loan. So you can imagine the heartache that caused. So to Barry's point, it really is important to check your UCC statements, do a UCC search as soon as possible, and make sure nothing like that's happened before a bankruptcy filing hits or something else happens.
Well, those are both good points. Let me add something to that, which is quite common with us. When we're engaged first to do an appraisal of the assets, we as appraisers do not confirm that a lender has a secured interest in the assets that we're appraising. That is not part of an appraiser's scope. With that, and that will be stated in the appraisal. When it comes to some sort of sale platform that we would do for the lender, be it a liquidation over a long time frame, an orderly liquidation, or brokered sale of the assets, or separately an auction, the first thing we're going to do is ask the lender or their counsel to tell us if that lender does actually have a UCC and does have right to sell those assets. And we, as the selling company, don't want to get into any liability issues, legal issues in any way of selling an asset that the lender believes is theirs, but it turns out is owned by possibly multiple lenders, or just the borrower outright, or maybe even a leasing company. So we're very, very cautious about selling, well, let's call it non-real estate assets, be it inventory, equipment. It could even be IP, trademark, patents. Those, of course, can be part of a blanket UCC.
what I was going to add to what Todd was saying, where this comes up more than any other time, is you look at the assets, you send someone out to do a site visit, you see the machinery, you see the computers, you see all these wonderful assets. You have them appraised by Todd, it comes back with a large appraisal. And then when you go to liquidate, you find out that much of the equipment is purchase money, meaning another creditor, after you came in, went ahead and either leased the equipment or sold them the equipment, and they paid cash, or they laid out the monies for that piece of equipment. Well, that is not going to be covered by your security agreement, even though you were there first and had a blanket security interest. Purchase money trumps with the UCC1. So that's something else to take into consideration. So you really have to know what your collateral consists of. A good example of a war story wise, a client of mine had loaned 7 figures to a scrap metal yard. They had nickel, they had copper, they had tin, they had all this piles and piles and piles. The mound must have been 15 to 20 feet high. And they looked at it and they figured, well, this is worth X amount of dollars. It turns out when we go to liquidate the company, and then we have an appraiser come out, they lifted the top layer of the copper and the tin, and all that was below was just dirt. They just built a mound and covered it. So when I say you got to get out there and kick the tires, you really have to see what you have, and you have to inspect. So you need appraisers who know what they're doing.
Yeah, I mean, I think, to your point, Barry, I think that's a very good one, because it's very common when we're called by a lender to ask us to either do a review or possibly even an update of an existing appraisal. A common question that we get is, well, can you just do a desktop and it'll help save us some money? And doing a desktop based upon information that was either provided by another appraisal firm or information provided by the borrower that the lender is now using as the inventory, whatever it might be, you're just kicking the can down the road and essentially not getting the full picture. And in a lot of cases, as you both had just spoke about, when you talk about rolling stock of any type, well, that rolling stock can roll right down the road and be gone in a matter of hours. So what you thought might be sitting in a yard or 2 or 4 may not exist at all. So if you're not going to go out and test the inventory to get photographs, to get current, when it comes to rolling stock over the road, to get current registration, that's a very easy way to track the if that over the road vehicle exists and that the borrower is keeping up the registration. That's one way of tracking it. And that way you're going to know if your inventory or whatever it is that's being appraised does truly exist where the borrower says it is. So the on-site inspection is literally if more important than the appraisal itself, because at least you know it exists. Agreed?
Yes.
Yeah,
Definitely.
Yeah, and especially now we'd be remiss if we don't mention what's going on in the world today with the COVID-19 pandemic and all the ripple effects that's causing through the economy and ultimately going to hit loan portfolios if it hasn't already. When we were getting ready when we were just chatting to get ready for this podcast, Todd brought up a really good point to Barry and I, which is, lenders really need to get their hands around their collateral, especially when it's personal property collateral, and especially during this time, because a lot of that stuff can disappear literally overnight. And given what's going on right now in the world and shutdowns and lockdowns, it may be difficult, but I don't think we can stress the importance enough of knowing what your collateral is and where your collateral is right now.
One of the things you need to look at the books, and sometimes there's more than one set of books, but look at the books And when you see that the company's inventory is going down, but the sales revenue is not increasing, you know the stuff is going out the back door. And some of the things you want to be able to look at. Or sometimes inventory is decreasing, and you ask the question, what happened to this inventory? Oh, we had water damage, we had fire damage, or we had theft damage. Well, then the next question you want to ask is, well, have you turned in an insurance claim? And of course they didn't, because there's no such thing as the fire damage or the water damage or the theft. They just are selling it out the back door for cash. And so those are things you want to be aware of. You want to have the right people who are capable of looking at the books and records. And again, you want to know what the inventory is that you have, so you can be able to assess what you don't have that you think you have.
You know, on that line, we just recently did a valuation of a furniture importer / manufacturer, and the lender had very little information on the current inventory, which was in approximately a 75,000 square foot industrial building. And I knew that that inventory was turning over some period of time, and the borrower now had stopped servicing the loan and was clearly getting into trouble. Well, we were engaged to go out there and kind of assess what the inventory was, how much of it there was, what the value was. And at the time we were there, the landlord happened to be at the property and had been in discussions with the tenant / borrower. And the landlord, who was extremely shrewd, made a point to state that the lease clearly denoted that the inventory could not be sold, could not be auctioned on the premises at that facility. Now, we don't start looking at leases until we're engaged to actually liquidate or auction assets. We don't do that on the front end as an appraisal, as part of our appraisal scope. And when I notified, once we did the appraisal and we talked to the lender about this situation, by the time we were done doing the appraisal, the borrower had essentially shut their doors. So here's, I don't know, at the time, maybe 60,000 square feet of, you know, thousands of pieces of furniture that if the lender intended for us to liquidate it or anybody else, they would have to spend the money to either pay the landlord and negotiate with the landlord the terms for access, but also pay for use of the property, or if the landlord didn't allow it at all, which this landlord did not, then the lender was going to have to pay to move all of that inventory. And we estimated the cost to move the inventory was somewhere around $100,000. So what nobody would ever have considered thinking about made the liquidation value of that furniture inventory reduced by almost a third. So, you know, these little aspects of the lending process have to be considered very carefully. I'm sure Barry or HEMAL, you've run into these situations as well. Wouldn't you agree?
Yeah, and I would add to that. You know, one to take off on one of your points there, Todd, on that story. I think what's important and what oftentimes goes overlooked on the front end when lenders are making loans and documenting loans is the obtaining and negotiation of landlord waivers and consents. A lot of lenders will just take whatever the landlord's willing to give them, obviously not expecting that they're ever going to have to enforce it. But in these kind of situations where you need to get to inventory that's at somebody else's building or yard, those become increasingly important. And oftentimes there's landlord liens that may take priority over a lender's lien if not properly documented. So that's another thing you need to check when you're kind of getting your hands around the collateral is what do your landlord's waivers look like and what rights are you going to have vis-a-vis a landlord if inventory or equipment is in somebody else's building.
We try to negotiate with the landlord. They're not thrilled about losing a tenant and losing the rent. So what we do is we negotiate it, and whether you call it storage or you call it rent, we try to keep, just because what Todd said, it's so expensive to move it, we try to keep the items on the premises. And sometimes if there's not enough items, it may be heavy equipment, and then it's very costly to move. So sometimes what you do is you do staging, and you bring in from, Todd may have 4 or 5 different auctions of the same industry going at the same time. You find one spot and you bring in the other equipment in. And then you're going to get a bigger draw of people, and you can get a better price, and you can sell more of the equipment. But we usually try to negotiate with the landlord in exchange for giving him rent. And then also we promise that we will clean up at the end, because that's always, it's always, when disgruntled tenants leave or are forced out, they always leave a mess behind them, besides taking things they shouldn't be taking. So we work with the landlord and tell them we'll bring our crew in to clean it up, so it'll be usable, and you can turn it over right away.
Yes, I mean, again, all these little nuances of understanding, what the credit is, and then the value of the credit on an ongoing basis is very important. I think it was you, Barry, you had mentioned, when you talk about UCC filings and understanding what the credit worthiness of that borrower is on an ongoing basis, or if it turns into a problem loan. Looking at the files, is there specifically documentation you like to obtain from the lender, or hope the lender has in their file? And if so, what might that be that would help you understand what kind of collateral might very well be under the lender's control?
Well, the basic is, of course, the security agreement, which is what your UCC financing statements is based upon. But then also you want to look in the file to see if there is an itemization of the equipment and or the collateral, what was purchased, what was it purchased for. That's the best way to do it. You want to be able to match it up. For those of us that have been around a long time, I remember 20 years ago, the big scam was the ATM machines that they would put in different places, and everyone was very excited because they thought to be getting a lot of money from the ATM machines. And it turns out that the same ATM machines were leased out to multiple borrowers at the same time, because no one bothered to go out and check. And so that's something else you want to be able to check to make sure that you have serial numbers where it's appropriate. But those are the documents I want to see what the client has, if they have taken the time to itemize what they have, what the inventory is. That's the most important part. So we know what to go after in case we have to go after it. Otherwise, it's a real problem. And then you may have to use a receiver, because many times the borrower, when you're at odds with them, will not let you have access to the property. Even though your security agreement says that you can have access, they're not going to give you access because they're already in default. So they don't care if they're further in default. So we're forced to put in a receiver, and a receiver who is an agent of the court will then has the power of the court to go in, and we take an inventory. And usually they're the ones that we use to sell the items. So we're forced to do that. We don't like doing it because receivers are expensive, but sometimes that's the best result, and it's the quickest result. And we want accuracy in what we do and what we're selling.
Very good point. One of the things I think is important when we're speaking about, underwriting, underwriting the actual loan and the ongoing review of the loan. even before it becomes a problem, is requesting from the borrower either a semi-annual or possibly even quarterly review of the inventory that you're lending on, whether it's finished inventory, work in process, or raw materials. But for sure, at a minimum, have a year-end inventory provided by the borrower. And it's generally our suggestion that either an appraisal firm or somebody from the bank do an inspection once a year to confirm that inventory, if they're giving it at the year end, they do it the first or second month of the following year to know that that inventory truly exists. We use inventories provided by the borrower in many cases as the basis for our evaluation, because physical counting every item becomes prohibitive, and even testing in itself, depending on what the inventory is, can be difficult. So reviewing that is very, very important in the file, and we find that so many lenders become remiss doing that. Emma, would you agree? Any thoughts on that?
I would agree. And I think a lot of it is not necessarily that they don't want to, it's just they don't have the resources necessarily to do that. And so what I've seen a lot of lenders do in this most recent economic expansion is outsource that service and the collateral audits and the inventory audits to third parties, which I think is a good practice. It obviously costs more money for the lenders, but it's a good fail state to have if the loan goes sideways and they're forced to try to enforce their rights and remedies.
When HEMAL mentions outsourcing, reminds me of something I've seen, because I get involved in a lot of equipment leasing, especially during this time when business is very slow or non-existent. So you have your borrower has a piece of equipment and he's not very busy. So all of a sudden, where's that equipment? Well, he leases it out there or rents it out to somebody else who is busy. And then when that person's done, it goes down to a third person who can use it, whether it be a backhoe or a bobcat or some other kind of printing press or whatever it may be. But that's, again, one of the reasons when you're starting to, when it becomes a problem loan, I'm not for waiting a year. I think you have to get more current information. And again, what people want to survive, and they have this equipment that they're not using, they are going to, and I'm not sure the word outsource, it's a nice way of saying it, but they're going to loan that out so they can get some money on their own. And that's something that they want to take into consideration, that you want to take into consideration when you're checking on your inventory and what you have.
That's a very, very good point. We were going to try to hold this first podcast to about 30 minutes, and we're approaching the pretty much, believe it or not, 30 minutes in already. One thing I would want to just state quickly in regards to the assets a lender has, when it comes to the real estate side of their collateral, we're finding with whether it's retail or industrial or just general commercial properties, even land specifically, we find that a lender almost never does either a site inspection. If they've done the first appraisal when the loan was booked, they never have any updates done until that loan goes over to special assets or the special servicer if it's a CMBS loan. And we find many situations that once it goes over there, and this may be 3, 4, 5, 6, 8 years later after that loan had been booked, the condition of the property itself has been so unkept or in such poor condition or has environmental issues that purely affect the value or marketability of that real estate. Either of you, Emma, you have any thoughts on that?
Yeah, so I think it's a good point. Right now, we're in Los Angeles, and here there's a severe housing crisis, and as a result, you're running across a lot of properties that are essentially been inhabited by squatters or homeless people, and so it's a real issue here, and it leads to all kinds of things that a lender should be concerned about, including fire risk and drug risks and all kinds of things that a lender wouldn't want going on their collateral. So I think Todd's point is well taken, that lenders need to keep up and understand what's going on with the collateral, even though it's real estate, and real estate, we all know, doesn't move necessarily. It is important to keep up with it. I know from the last recession, a lot of borrowers, what they do is their loans would go into default. They wouldn't tell the lenders that their tenants had all left, and they essentially started running hotels in apartment buildings, basically renting apartments out by the night, and which obviously leads to a whole host of problems and issues. And then the lender would foreclose, take it over, and be confronted with a whole lot of problems that they'd have to try and fix.
Yeah, that's a good point. And we have a situation that we were just dealing with where a lender has a position on a reasonably large mid-tier hotel that, of course, with the COVID issues was closed down, but the borrower, the owner of the property, was able to obtain the state payments from the state of California to use the hotel as a supplementary, call it holding facility for people that have the COVID virus. And the state was paying full occupancy for this 180 some room hotel. Well, the hotel is being used essentially to house sick COVID people that have the COVID virus. Now, I know for a fact, after speaking to the borrower, that he was not taking into account what kind of effect that may have on the property itself and what kind of disclosures he's going to have to make, or the cost to actually remediate the property once the state is done using it. And once we reported that to the lender, I can tell you the lender was extremely unhappy. They're in the process of having discussions with that borrower. So something interesting that, of course, we wouldn't normally think of. HEMAL or Barry, do you have anything in closing you want to add?
Not on this subject. I'm okay. I'm all set.
Well, okay. And everyone, I know 30 minutes went by very quickly, and we have got just a litany of things to talk about. And we appreciate you all listening to us banter about our experiences. And we look forward to our next month's podcast, and keep you informed. And any questions, of course, you can reach out to any of us. If you have any direct questions about what our companies do, but more importantly, questions or thoughts or concerns, anything that you're dealing with could be a very good topic for a future podcast. And with that, I will say thank you, Barry Smith of Buckhalter, and HEMAL Master of Franzel, and I'm Todd WOHL with Braun International, and want to thank you all for listening, and have a good week. Thank you very much.